Hello, this is Jackie Jones, and this is the second module in week 2 of lectures in family law. And this lecture is going to be about affidavits. The affidavit being a document that sets out the evidence to support the orders you're seeking in the application. And module 1 talked about applications that are filed with the court, and in your assessment task, you'll be filing that application in a case seeking interim orders, and your affidavit in support of that application will set out the evidence to support the orders you are seeking on behalf of your client. So when you are going to be drafting an affidavit, stand back and think about what it is that you're drafting. So you are drafting the evidence of your client. What is it in the context of the judicial officer? Where does it sit in the plan of what the judicial officer does with that application? Well, the judicial officer will consider the application and look at the actual orders that the party is seeking. What orders does the party ask the court to make? And then the judicial officer will go to the affidavit. Does the evidence support the orders that are being requested by a party? Importantly, in an interim hearing in the family arena, the application in a case are normally dealt with on the papers. That means that a party does not go into the witness box and is subjected to cross-examination by the other side. But when you are preparing your affidavit, you must remember that there is a necessity to comply with the rules, including the Evidence Act, and you'll see there on slide 3 certain sections of the Act and the rules for you to be mindful of. Importantly, in any affidavit, just like when you prepare and submit a research paper in core or elective, you make a plan before you start. Think about what is it that you're wanting to address. The use of headings, for example. Get your information into headings. The first draft is not going to be the one that is going to ultimately end up in court. What I need you to think about is having an affidavit that is well structured, that think about it from the perspective of the reader of the affidavit. Is there a logical flow of the evidence that is being given by the person who is the deponent of the affidavit? And importantly in the affidavit, if it is a particular matter, such as a parenting matter, go to the Act and address what is required. What is required for the best interests of a child? Go and look at section 60cc as to the elements that a court is required to consider. It might be a spouse maintenance application. What is it that the court is required to consider in a spouse maintenance application? Or it might be a property adjustment, and the court is going to be mindful of the contributions in section 79(4), for example, if it's a married couple, or the appropriate section if they're a de facto. So it's not just what a client is wanting that is included in the affidavit, but rather the evidence that specifically support the orders that are made and what addresses the legislative requirements for that particular aspect or the particular matter for the court. Importantly, the affidavit must comply with the court rules. Is the evidence relevant, for example? Clients will tell you a lot of information. Not all that information is relevant. It might be important to them, but as lawyers, we need to be a sieve. We need to sift through that information and determine what is it that we're asking the court to consider, what is the basis that the court's going to consider on, what are the issues in dispute, and what evidence relates to those facts and issues. Of course, the evidence must be in admissible form. There is provisions that there is certain leeway with regard to interim hearings, but my tip is that always try and structure your affidavit in an admissible form, because that is a very good practice to get into. Now, another thing with an affidavit is that it must be sworn or affirmed by a deponent. This is not something that is your choice. It is the choice of a client. So you need to have a conversation with the client. Are you wanting to swear the truth of this document by a religious oath, or are you wishing to affirm the truth of the contents? Clients will often say, well, which one's better? And in fact, no one is better. There's no greater weight attached to an affidavit that is sworn in comparison to an affidavit that is affirmed. Affidavits also must be witnessed, and in this regard, big flashing light about your duties that have been discussed, for example, in legal and professional skills, as well as your ethics component in your core subject. You can't witness a document if you haven't seen that person sign it. Now, also with affidavits, there may be that there are material that are attached or annexed to that affidavit to be part of the evidence to assist the court in making a determination. Now, to annex a document, that document must be one capable of being annexed. Is it in admissible form? Can it be admitted, for example, as an annexure? Is it something that should be in an affidavit itself rather than be part of an annexure to somebody else's affidavit? Is there a requirement for it to be marked? So if, for example, you are referring to an annexure A, then that annexure, that mark number A needs to be on that annexured page, and there needs to be an annexure or an attachment clause. That being, this is annexure A referred to in the affidavit of Mary Smith, sworn on 1 December 2015 before me, Jackie Jones, solicitor. Now, if I'm the person who is the witness to the affidavit, then I'm the one that signs that annexure clause, and each annexure clause must have that particular statement. Objections. Now, objections are taken to affidavit material. The court does have power to strike out affidavit material, and objections are made. Please don't think that the court just accepts all material, or that the other side will not take objections to your client's affidavit material. I have sat in hearings where the best part of a day, 2 days, is just confined to dealing with objections to affidavit material. And the court does strike out material. And there is nothing more humiliating than, in fact, sitting there while your material that you've drafted, that your client has paid for you to draft, and your client's sitting there behind you, and the other side is objecting to it because it's not in admissible form, and the judge agrees, and a big red pen comes and strikes it out. And certainly His Honour Justice Thackeray of the Family Court has a comment on that on slide 7. Even short affidavits are ones that need to be rewritten and considered and assessed. The first draft isn't the one that ultimately will be filed in the court in most instances. And His Honour has given a number of comments there about what should and should not go in an affidavit. When we were talking about objections, I remember clearly a matter that I was in, and there were allegations of drug use by both parties. The solicitor for the other side had drafted and filed a number of affidavits which referred to my client's drug use, and in the affidavit the statements were that the particular deponent observed my client taking cocaine. Now, that was an assumption, and the way the affidavits were drafted ultimately were the subject of objection. Objections were upheld by the court, and material that had been drafted by, and I must say I was an experienced practitioner, literally just was wiped off the affidavit. The affidavits that I had drafted in relation to the wife's drug use was something along the lines of the deponent observed the wife um, uh, inhale a white powdery substance by placing a rolled piece of paper to her nostril, putting a finger to one side of the nostril and then inhaling the white powdery substance with the folded piece of paper. So the evidence was what was observed, not the conclusion that the wife was using cocaine. So you need to be careful, particularly when you've got fairly contentious matters, and sometimes it is one that if the evidence isn't put in an appropriate format, then it doesn't come before the court. I learnt the hard way about having a balanced affidavit. I was doing a parenting case, one of the first contested parenting cases that I was involved in, and my client was the father of the two children. The two children were living in the country with the wife and her new partner, and she was in a same-sex relationship, which she didn't admit by way of evidence, but ultimately did come out. I had on affidavit in support of my client's application for the children to live with him, his parents, but also her parents. Her parents thought that she had a degree of instability, that there were some aspects that were troubling to her and troubling to them, and her ability to care for the children. And so they were supportive of my client's application for the children to go and live with him. The matter came before Her Honour Justice Maxwell, who was one of the first judges of the family court, appointed in 1975, very experienced judge. And Her Honour taught me a very valuable lesson, because the affidavits I had prepared really weren't balanced. There wasn't a positive comment about the wife in the affidavit. And from that moment on, I learned how important it was to have a balanced view of the other side, as well as projecting your client's story to the court. And another very important lesson is never use the word never. Particularly in family law matters, it's very people can be quite inclined to say she never was involved in the garden, she never maintained the home, he never cared for the children, he never took them to birthday parties, he never gave them fresh fruit and vegetables. Never's a big word. I don't use the word never, and I would encourage you all not to do so. But what you can do is you can say that the deponent can say, I have no recollection, or on limited occasions, or I don't recall. So there are words that can be used rather than the blanket never. Just keep that in mind. Slide 9 just deals with witness on affidavit, and I've just put it there because I just want you to make sure that there even though the Oaths Act is a state piece of legislation, Law Cover certainly has advised that it thinks that the certification should apply even if affidavits are filed in a Commonwealth Court such as the Family Court or the Federal Circuit Court. Now, for your assessment task, the signature on documents. If you are going to be the solicitor and you are signing as the solicitor, then you can certainly sign your name. If you are witnessing or if you're signing the application on behalf of your client. But we want you to, for the client signature, to put signed by and then insert the name of the client. So don't create a signature, but rather use the terminology signed by Mary Smith, or whoever the name of your client is. And that's the end of this module. Thank you.